glad we were able to connect. My name is Kelly Shaban, and I am with Home Base.
I'm Maya Spark, also with Home Base.
So we are working with the Monterey, with Roxanne and the Monterey COC for this year's COC competition. And so something that we discussed with Roxanne was the idea of bringing Violence Against Women Act, which we're going to refer to as VAWA, and the Emergency Transfer Plan into compliance with your policies and procedures. So I don't know if you've had an opportunity to talk about the Emergency Transfer Plan addendum that you may be adopting today or voting on today. But this is just to give a little bit more context to that addendum and to learn a little bit more about the process that I believe you're going to try to adopt in Monterey. And yeah, so Maya will run through the presentation, and then we'll save time for some questions at the end. But this is not meant to be, we understand that this is a lot of information we're throwing at you, so please just, today's overview, we're just trying to give you the larger context, and of course, if you have more specific questions moving forward, we're also available via email. We'll provide you that email address.
Okay. So first, a lot of you are probably already familiar with VAWA, but what's important to know is that protections for survivors in HUD-funded programs started in the final rule of 2016. So that was kind of the latest VAWA update that really applies to COC programs. With each authorization of VAWA, it's grown a lot stronger in its protections of survivors and also more inclusive. So this is a pretty important part, which is how does VAWA define a survivor? How will we be using the term survivor in the presentation today? VAWA is intended to have a very broad, inclusive definition of domestic violence. There's a lot of different definitions of domestic violence, but VAWA does have its own. And so you'll see that VAWA covers victims of domestic violence, dating violence, sexual assault, stalking, and this includes human trafficking. Domestic violence itself does include crimes of violence committed by a current or former spouse or intimate partner, by a person with whom the victim shares a child in common, someone they're cohabitating with. It's intended to be quite broad. And there is kind of a broad section that basically says, by any other person against an adult or youth victim who's protected from that person's act under the domestic or family violence laws of the jurisdiction. So one example that people don't often think through is elder abuse. So again, broad, inclusive definition, and this is the definition of survivor that we'll be using today. We'll talk about emergency transfer requirements that VAWA requires, specifically for COCs. As Kelly said, you all are going to be reviewing or have reviewed an emergency transfer addendum, so this is some context on that. So as of 12/31/2017, all funded COCs need to have an emergency transfer plan in place under VAWA. The requirements under VAWA for COCs include establishing this emergency transfer plan, making the emergency transfer plan public, and making sure that tenants in COC funded programs know about the plan, keeping a record of emergency transfer requests for 5 years and reported to HUD, and then including your emergency transfer plan in your written standards, which I believe is what you all were doing today. So who qualifies for an emergency transfer? So if the client is a survivor, as defined previously, and they expressly request the transfer, and either the tenant in a COC-funded program reasonably believes there's a threat of imminent harm from further violence if they remain in that unit, or if they were a victim of sexual assault on the premises during the 90-day calendar period. So basically, we want people to feel safe where they're living, and if they don't, and they've expressly requested a transfer, then the emergency transfer process is intended to cover that person. As most of you know, there's often a long community queue for COC housing, And so this process is intended to be kind of a parallel process that makes sure that we're prioritizing people who might already have received a unit that need to transfer to a different unit for safety concerns. Okay, so emergency transfer plans have to talk about the priority of people seeking an emergency transfer in relation to other households. So as I mentioned, there's usually a community queue through your coordinated entry system that places people on a priority list for when they receive housing. So this plan has to talk about what priority people requesting an emergency transfer plan has to have. And basically, VAWA internal emergency transfer requests need to receive the same priority provided to other types of emergency transfer requests. And so we're going to talk about the difference between an internal and external transfer in a little bit. Something to note about this training is that even though emergency transfer requests need to be top priority on a community queue list when they're requested, there still are eligibility criteria by housing type that have to be followed. So VAWA doesn't override those eligibility requirements. And usually those are, you know, like PSH for chronically homeless individuals, things like that. Okay. So this is talking more about emergency transfer plans and the requirements. This includes the prioritization scheme again, and it needs to talk about the efforts that providers will take once they receive an emergency transfer request. And so these are kind of some best practices that providers can do to encourage emergency transfer requests and for tenants to feel safe so that they can have MOUs with other providers. So if you receive an emergency transfer request and you don't have a unit for someone, maybe you have an agreement with someone else that you'll try to make room in each other's housing units for survivors who are requesting these sorts of transfers. And then, you know, working with victim service providers and organizations that assist with finding housing for survivors. It also wants to make sure that your emergency transfer plan talks about what happens to tenants that have tenant-based rental assistance that's COC funded. As you know, a lot of people are living in a private unit with a landlord, and you may be paying, you know, tenant-based rental assistance for that. And so what happens to that if the tenant then has to move, say break a lease, those sorts of considerations, which we'll talk about a little bit more. So an internal transfer, basically you have someone in your program and they need a transfer and they're requesting it within your program. So if you have a safe unit, you're supposed to do everything you can to immediately transfer them to a unit where they feel safe. And so these requests, as I said earlier, should receive at least the same priority that the program provides to other types of emergency transfer requests. If a safe unit isn't available within the provider's program where the survivor currently resides, then the participant can choose to wait if they really want to stay in that program with that provider. They can request an external emergency transfer to a different program, and they can pursue them both at the same time. External transfers. And so this is what I was talking about with the by name list and coordinated entry. A participant requesting an external emergency transfer has priority over all other applicants for COC funded housing assistance. So if you're doing your case conferencing and you're reviewing the top people that you have on your community queue list, and an external emergency transfer comes through that meets eligibility requirements for the next unit you have available, then they get priority over all other people on that list. And that's when the person running your coordinated entry system facilitates the referral of that participant to that unit. And just so you know that you know, say it's PSH or other types of units that prioritize chronically homeless individuals, the household, just because they're transferring through an emergency transfer to a new program, they are retaining their original homeless or chronically homeless status for the purposes of the transfer, even though they've been being housed previously, because they were originally qualified and they're just transferring within COC programs. So here's some special notes. Every time you're dealing with emergency transfers, you want to be thinking through safety and confidentiality. You want to make sure you're not disclosing the location where they're being transferred, obviously. And then you want to be thinking through what happens to the non-transferring family members, particularly if they're receiving tenant-based rental assistance. So as we know, sometimes domestic violence can separate families. So there's a lot of considerations, like what if the person that originally qualified for the tenant-based rental assistance is the one who's moving, things like that. And we're going to talk more about that sort of family separation in a little bit. Required documentation. So this is intended to really be low barrier. We don't want to ask people for a lot of documentation. This is really following kind of trauma-informed care principles. We don't want to re-traumatize people by making them tell their story over and over again for different documentation purposes. And so the provider can require a written request from the tenant certifying that they meet the criteria for the emergency transfer, and they may ask the tenant for documentation of the occurrence leading to the request, as long as they haven't already had to provide that, say during the VI SPDAT process or another process. So no other documentation is required to qualify the tenant for an emergency transfer. And in your policies and procedures, there are ways to make it so that only the COC and the provider is able to make these documentation requests rather than private landlords. And so if you're interested in learning more about that at some time, again, like Kelly said, we're available by email. Confidentiality, touched on a little bit before. This emergency transfer requests and their locations need to be kept in strict confidence. I'm sure that you have provisions when you're doing your case conferencing and coordinated entry about how you're maintaining confidentiality when you're discussing those individuals who come up on the by name list that are survivors. And so the information should not be put into a shared database like HMIS. And if it is, then they need to make sure that they've gotten consent from that individual, or obviously if it's a matter of law. It's just really emphasizing strict confidentiality measures. Okay, so bifurcating leases, this is something that we talked briefly about when we talked about the potential for family separation in units during emergency transfer requests. And so a landlord, and this is very applicable to tenant-based rental assistance mostly, may bifurcate a lease to evict or remove a household member who engages in the DV-related criminal activity. So essentially this means that a landlord can divide a lease as a matter of law. And so part of the family that are the survivors of the violence can be still living there and not be evicted, and they can remove the perpetrator from the household, even if they were a member of the lease in the first place. And so we really want to try to make sure that families are not being evicted just because there's domestic violence going on in the household. And so this is a way to make sure that survivors can stay in the home. And the COC funded tenant-based rental assistance and utility assistance continues for those people who remain in the home. And if the person who was removed, the perpetrator removed that was taken off of the lease was the person who qualified for the housing in the first place, like PSH, then the remaining members may stay until the lease expires. So this is essentially making sure that everyone receives notice that they have these rights through the emergency transfer process and that they're protected by VAWA. And so it's obviously difficult to identify and impossible to predict when domestic violence might occur. So grantees need to provide each individual or family applying for any of these program types these sorts of notices. In order to be subject to these VAWA protections, we need to make sure that leases in TBRA situations contain provisions that basically say that survivors can't be denied or have their assistance terminated or be evicted just because of their status as survivors, and that a person can't be, all the other ways that landlords can use to evict someone. DV should not be one of those and can't be grounds for claiming a repeated and serious violation of a lease, or kind of a just cause if there's a just cause eviction statuses in the community. Okay. So this again talks a little bit more about tenant-based rental assistance and the requirements when you as a provider have contracted with a landlord about the different notices you need to provide. And then if they're not tenant-based rental assistance, it imagines that the program and the participant have some sort of lease or contract, and so the agreement to allow people to terminate that agreement with the provider if they need to request an emergency transfer would happen between the program participant and the program, as opposed to landlord and the provider, or landlord and the tenant. Okay. And so the big thing on this slide is just a lot of leases auto renew, so we want to be sure that these terms are in all leases. Okay, limitations of VAWA. So again, this talks about how they may not be terminated because they're a survivor, but there are some public safety reasons that evictions can occur. And so the intent is to make this a really high barrier that someone needs to prove to be able to evict someone, and that they're not just using the fact that they're a survivor as the reason. So really what we're trying to get at is that we really want eviction and termination really as a last resort for survivors. And so what we're really trying to do is transfer people to different units, trying to come up with creative ways to bar people from the property, having law enforcement around, seeking other legal remedies such as restraining orders, which a lot of victim service providers will provide accompaniment for. And so this is just trying to get your brain thinking about all the different ways that you can keep a survivor housed and not have to evict or terminate their tenant-based rental assistance just because they have this domestic violence situation ongoing. This talks about if you have a coordinated entry system and you're having a non-victim service provider do an assessment of a survivor, the best practices are to have an immediate warm handoff to a victim service provider, and if they're able to, I'll give them the VI SPDAT. If you have gotten the VI SPDAT at your agency after a survivor has been matched to your agency, and you have their consent, we still need to be entering survivor data anonymously into HMIS. However, in the coordinated entry system, hopefully, if you have a COC funded victim service provider, they know that they're using a comparable database and not HMIS for their initial intakes. This is another best practice. Ideally, when you're intaking and assessing someone, you're separating them for their assessment. Obviously, results can be very different and very skewed if you're assessing people as a family and in front of their abuser. And so if you notice that a survivor was given a family VI SPDAT that's used in your region, then they should be reassessed under the individual VI SPDAT confidentially and by themselves. California housing laws, these are just a not comprehensive, but list of laws that could be applicable in these sorts of situations that it might be helpful for providers to know about. If you have tenant-based rental assistance or a private landlord, they're required to change the locks within 24 hours of receiving a request in writing and a court order excluding the abuser. So say they've bifurcated the lease, and you then want the locks changed, that is something that they have to do. And then this again talks about not being able to evict a tenant based on their status. And so the tenant, if they keep allowing the perpetrator onto the property, then that can become an issue that isn't coverable. So just like other evictions, they have to at least be given 3 days notice to correct the violation, aka have the person leave the property. Or if the landlord notices that the person keeps coming back and they think that they could be a threat to other tenants. So again, really around public safety. That's pretty much it. I know that's a very fast overview of VAWA and the emergency transfer process.